Good evening. How's everybody doing? Great to be learning with you on a Sunday, Yom Rishon. Let's light up the darkness. Who's in the house? Sharon in New Jersey, Yehudit. Bill in Mid-Missouri. Joseph in Massachusetts. Sharon in the Bronx. Alyssa in Philadelphia. Melissa in Great Neck. Joe in the Inland Empire. Karen in Northern California. Guy in Ohio. David in Indiana. Bella in Florida. Paula in Chicago. Lucy in Minnesota. Ella's with us. Marjorie is with us. Lynn, not in North Texas, but in Silver Spring, Maryland. Welcome, everybody. Let's do this. Our daf today is page Ayin Aleph, page 71 here in Tractate Gittin. We're working our way through chapter 7. Today we'll complete our discussion of Mishna number 1 here in chapter 7. Tractate Gittin are the laws of divorce, and we've had many digressions, but now we're actually talking about the get, about the bill of divorce. And Mishna number 1 here in chapter 7 said that if a man, while he was having a bout of temporary insanity, instructed somebody to write a get for his wife, we don't listen to him. Or if he desired that a get be written for his wife when he was lucid, and then he became temporarily insane and canceled the instruction, again, we don't listen to him when he's insane. Then the Mishnah also talked about one who became mute or who became deaf. And then what is the validity of his instruction after that? And now we're going to continue with that discussion. Page 71a, right near the top. Rav Kahana says that Rav says, with regard to a deaf mute who can express himself through writing, the judges of the court may write and give a bill of divorce to his wife based on his written instructions. And Rav Yosef said, what is he teaching us? We already learned in the Mishnah, in the case where the husband became mute, and the members of the court said to him, shall we write a bill of divorce for your wife? And he nodded his head, indicating his agreement. They examine him with various questions 3 times to make sure that his nod is actually a responsive nod. He's lost the ability to talk. But if he can indicate a yes or no answer to a series of questions where you need a yes sometimes, you need a no sometimes, and he's clearly understanding what it is that they're asking him, okay, so then he can confirm that he wants this bill of divorce written, even without speaking the words, and we listen to him. So what novelty are we learning at this point from Rav Kahana in the name of Rav is what's being asked. What is he teaching us? We already learned in the Mishnah, in the case where the husband became mute and the members of the court said to him, shall we write the get? And he nodded his head, indicating his agreement. And they examined him with questions 3 times. And if he responded to questions that require a negative answer with a no, and to questions that require a positive answer with a yes, this indicates that he's competent, he understands what he's being asked, and therefore they write the get at his instruction and give it to his wife based on the nod of his head. So what novelty are we now learning? So Rabbi Zera said to him, a mute, you say? Is your challenge based on the Mishnah, which discusses one who is mute? A mute is different because it is clear that his mind is intact. And so now the Gemara is going to proceed to distinguish between a mute, a deaf person, and a deaf mute. And it's only the deaf mute that was considered legally incompetent, like an imbecile or a minor, that he doesn't have legal standing. And of course, in modern times, we've seen that, sort of like we've developed the ability with somebody who is unable to hear or speak. Now we have other ways of communicating with such a person, and he can indicate to us that he is competent, that he is of sound mind, and we know what it is that he wants legally from him. But in ancient times, that was much more difficult to determine, and so that's the context of this discussion. Right, so Rabbi Zera says, a mute, you say, a mute is different, because it is clear that his mind is intact. because we can ask him questions and he can hear what's being asked and then respond by nodding his head. That's what we've been discussing. As it is taught in a Baraisa, in the Tosefta of Tractate Terumos, 1:2, with regard to one who speaks but cannot hear, this individual is categorized as a deaf person. And with regard to one who hears but cannot speak, this individual is categorized as a mute person. And both this one and that one are considered to be like halakhically, legally competent people with regard to all their matters. So Rav Kahana stated this ruling with regard to one who can neither hear nor speak. This goes beyond the law of the Mishnah, as Rav Kahana says that the written statement of a deaf mute is an indication of his mental competence. So that's something new. Right now we're discussing not just one who can answer questions with a nod of the head and show that he understands what he's being asked, but now we're talking about a deaf mute person who is able to write out what it is that he wants. Right? I don't know if he was born deaf mute or what, but this person was able to learn how to read and write. And it would seem that that's going to be a very solid way to communicate and demonstrate to us that he absolutely knows what's going on. So the Gemara asks, and from where do we learn that one who speaks but cannot hear, that this individual is characterized as a deaf person, legally a deaf person, and that with regard to one who hears but cannot speak, that this individual is characterized as a mute person? How do we know this as a legal definition? As it is written, quote, "And I am like a deaf man, I do not hear, and like the mute man who will not open his mouth." Psalm 38, verse 14. And if you wish, say, as people say, the word for a mute, ilem, is a contraction of the expression, his speech has been taken, ishtakil milule. Now, Rabbi Zera said, if Rav Kahana's statement is difficult for me, this is what is difficult for me, as it is taught in a Baraisa with regard to the punishment of one who is called to testify and failed to do so. If he does not utter his testimony, then he shall bear his iniquity, from Leviticus 5:1. And the sages derive from this that the verse serves to exclude a mute who is unable to utter his testimony, and he is exempt from bringing the offering of one who commits a transgression by refusing to testify. And then if he needs to make if he's going to make an atonement for that transgression, he has to bring a certain offering. But a mute who is unable to speak in court with his mouth is exempt from bringing such an offering. And it is possible to raise the following question: why is he exempt from bringing the offering? But he is able to utter his testimony through writing. So apparently, written testimony is not valid testimony when we're talking about testimony in a court of law. And that stands to reason, right? When you're talking about, they didn't have juries, right? But they had judges. And for a judge to evaluate whether a witness's testimony is compelling enough to produce a verdict or to overturn a verdict, the judge, or in modern courts, a jury, right, is judging a lot more than just the content of the testimony. He's looking at the witness, he's evaluating the witness. How does the witness sound? Did we think he's lying? Is he being truthful? Is he hesitating? What is the extent of what he saw and that he's testifying about? And a lot more gets communicated in a court of law when the witness testifies than just the content of his speech. And so if he put it in writing, that is not the same as a witness's testimony in an open court. So Abaye said to him, "You say testimony. Testimony is different. As the Merciful One states, Deuteronomy 17:6, quote, from their mouths, which emphasizes that testimony must come from the witness's mouth and not from their writing." And the Gemara raises an objection to this based on that which is taught in a Baraisa. Just as the judges of the court investigate him, one who lost his ability to speak, with regard to bills of divorce, so too the judges investigate him with regard to business transactions, testimonies, and inheritances. In any event, it teaches testimonies, which proves that even one unable to speak can give testimony. Now, that doesn't mean that he gives testimony in writing. He can appear in court, right, and nod yes or no. And again, the judges have the ability to look at the person in the eye as he's answering questions, even if he's not answering with his voice. Now, Rav Yosef Bar Minyumi said that Rav Sheshes said, this is not referring to testimony in general. Rather, it is referring to testimony with regard to a woman whose husband died, as the sages were lenient with her and allowed testimony that would normally not be accepted in order to save her from being an aguna, a stranded wife. We've already seen that there's a leniency that normally we only establish a matter by the testimony of two witnesses. So for someone to establish that a woman's husband has died so that she is permitted to remarry, it should be that we require two witnesses to that death. But it can happen that the husband went away to war. There was only one other soldier who saw that he fell in the battle. The body was never recovered. No one else can testify that this man died. And as we saw, the sages allow this woman to remarry based on the testimony of the single witness, although she's taking a risk that if the husband then actually comes back and he wasn't dead, she's going to have to divorce the next husband. She's not going to be allowed to marry the first husband. She's going to have a huge problem. And so we expect that she will take every opportunity at her disposal to confirm the testimony of this single witness. But at any rate, we see that leniency to protect her from becoming an aguna. So perhaps we'll also have a leniency that testimony that would normally be required to come from the mouth of the witness, perhaps we'll accept it with just nodding, or perhaps we'll accept it with in writing. Let's see. The Gemara challenges. But isn't it also taught inheritances? And this seems to be referring to monetary matters, where proper testimony is required. And Rabbi Bahu said the Barais is referring to the inheritance of his own firstborn son, meaning that he is not testifying about other people's property, but testifying which one of his sons is the firstborn. This maybe we'll allow in writing, but we wouldn't allow him to testify about somebody else's family. Since this testimony is merely considered to be a division of the property that belongs to him, the father, the testimony of one who is unable to speak is valid in that situation, but in the normal situation, it would not be valid. And the Gemara continues to challenge. In any event, it teaches in the Baraisa with regard to business transactions. So what? Does it not mean that a mute may testify with regard to business transactions for everyone else? And the Gemara says no. He may testify for himself only. The Baraisa is saying that when a mute conducts business, the court must first check if he is mentally capable of entering into those business transactions. Right? Remember that saying that a deaf mute is not legally competent is ultimately for his protection, so that people don't take advantage of him. Now the Gemara raises an objection from a Baraisa. With regard to a deaf mute, the judges of the court follow his signals and follow the movement of his lips and follow his handwriting, only for matters of buying and selling movable property, but not for bills of divorce. So this appears to contradict Rav Kahana's statement that it is permitted for a deaf-mute husband to give written instructions to divorce his wife. So the Gemara answers, it is a dispute between Tanaim, the rabbis of the Mishna, as it is taught in a Baraisa that Rabban Shimon ben Gamliel said, in what case is this statement that the court may not rely on the written testimony of a deaf-mute with regard to a get said? Right? When is this said? Only in the case of a deaf mute who was deaf from the outset, meaning from birth. But if he had been halakhically, legally competent at some point in his life, and later he became deaf, and he became a deaf mute later, then he may write instructions because we understand that he's of sound mind. Whereas if he was a deaf mute all his life, at least the way the sages understood it then, they could never be sure that this person really understood what was being asked of him. Entering into a marriage, entering into a business deal, dividing an inheritance, etc. So the Gemara asks, and one who is a deaf mute from birth, cannot give written instructions with regard to a bill of divorce. Is this so? But isn't it true that just as he marries her with intimation, i.e. without speaking, but rather with gestures, so too he divorces her with intimation, meaning with gestures? And the Gemara answers, if the Baraisa is referring to his wife, indeed this would be the case, and he could divorce her through intimations, because such a marriage is not a fully valid marriage by Torah law. But with what are we dealing here? With his yevama, right? His sister-in-law, whose husband, his brother, died childless, and to whom he performed yibum, levirate marriage, and whom he subsequently wishes to divorce. This marriage is a fully valid marriage. And the Gemara asks, his yevama from whom? If we say that she fell to him from his brother, who was also a deaf mute, then just as her marriage to the brother was through intimation, so too her divorce from the yavam can be through intimation. Rather, it must be that she fell to him from his halakhically competent brother. Consequently, the bond of the levirate marriage is by Torah law, whereas the deaf-mute man's intimations that he desires to divorce her are valid only by rabbinic law. Right? So under Torah law, we require that a person be able to, perform certain actions in order to be married. So by Torah law, the deaf-mute cannot marry. But we've already seen in this tractate that by rabbinic law, the deaf-mute can marry. Now, Torah law trumps rabbinic law, but rabbinic law enables the deaf-mute to marry, which is, a wonderful decree that the sages issued. But one who marries by yibum, right? A man who died childless, and he left a widow. So let's say that man, was legally competent. He left a widow. His brother was a deaf mute. Now, the deaf mute normally only marries by rabbinic decree. But when he performs yibum with his brother's widow and the brother died childless, that marriage is a marriage by Torah law. So now you have a problem that deaf mute marries by rabbinic law and divorces by rabbinic law. But if he's now become married by Torah law, how is he going to perform a divorce? Maybe he's stuck in this marriage forever. And the Gemara answers, if the Baraisa is referring to his wife, indeed this would be the case, and he could divorce her through intimations, because such a marriage is not fully valid marriage by Torah law. But with what are we dealing here? With his yevama, his sister-in-law whose husband died, etc. Oh, I'm sorry. I just read that paragraph again. And if you wish, say instead, actually explain that the wife fell to him from his deaf-mute brother. The original marriage was with a deaf-mute man. And the sages instituted a rabbinic decree with regard to a woman bound in a levirate marriage from his deaf-mute brother due to the death of his halakhically competent brother. So the Gemara challenges. If so, and the sages made such a decree with regard to a case where a deaf-mute brother died due to the case where a brother who was halakhically competent died, then with regard to his own wife as well, they should have made a decree that a deaf-mute husband cannot divorce her with a bill of divorce if he married her as a deaf-mute. And the Gemara answers, his yevama, this widow of a man who died childless, who was married to a halakhically competent brother, might be confused with his yevama, who was married to his deaf-mute brother. But people would not confuse his own wife with his yevama. Therefore, there was no need to institute such a decree. Right? When they say, when they say that they instituted a rabbinic decree with regard to a woman bound in yibum from a deaf-mute brother due to the death of the halakhically competent brother, what they're saying is sometimes they issue decrees because people will get confused without the decree, right? And so they would, by rabbinic decree, they would say, well, we're going to treat the deaf-mute in this yibum situation the same as the one who is halakhically competent, lest people come to make a false distinction, right? It's just, again, it's the sages are always thinking what will be the consequences of making a decree or not making a decree in terms of will the public be confused. Now, the Gemara asks, and do we, the sages, decree with regard to his deaf-mute brother due to confusion between him and his halakhically competent brother? Now we're on 71b. But didn't we learn in a Mishnah, in Tractate Yevamos, page 112b, in a case where there were two deaf-mute brothers whose marriage is valid by rabbinic law, married to two halakhically competent sisters, or to two deaf-mute sisters, or to two sisters, one of whom was halakhically competent and one of whom was a deaf-mute. And similarly, if there were two deaf-mute sisters whose marriage is valid by rabbinic law, married to two halakhically competent brothers, or to two deaf-mute brothers, or to two brothers, one of whom was halakhically competent and one of whom was a deaf-mute, and in each case, one brother dies without children, then all these women are exempt from chalitza and from levirate marriage, right? Because there were marriages here that were created by rabbinic law, not by Torah law. If a widow falls for yibum to the surviving brother after her husband dies, because it was a marriage by rabbinic decree and not by Torah law, there is no yibum situation that she should marry the brother or need to perform chalitza in place of marrying the brother. And if they were unrelated women, the men may marry them in yibum, and if they wanted to divorce them later via a get, they may divorce them. Since this is stated as a general law, it indicates that the deaf-mute brother can also give a bill of divorce to his yavama, who was previously married to his deaf-mute brother. And the sages did not institute a decree in order not to create confusion with the similar case of a deceased halakhically competent brother. Rather, it is clear, as we initially answered, that it is referring to a yavama previously married to a halakhically competent brother who fell before a yavam, right, before her brother-in-law for yibum, who was a deaf-mute from birth, right? She was married to a halakhically competent man. He died childless, and now the surviving brother is a deaf-mute. Does she perform yibum with him? Or does she need to perform chalitza if they don't want to get married? And the alternative answer given on the previous Amud is rejected. So on the previous page is rejected. So Rabbi Yochanan says, the colleagues of Rabban Shimon ben Gamliel disagree with him and hold that written instructions from a deaf-mute have no halakhic validity. That's the question. They're going through these very complicated proofs and bringing this ultra complicated example from, remember how complicated that whole tractate was, Yevamos, about when, the basic law is a woman is widowed, her husband never had a child, he left a brother, so she now has to marry that brother, and the first child that they have will be considered the heir of the brother who died without having children. And if the surviving brother and the widow don't want to marry, they perform this ritual of chalitza. That was the simple law. But then there were so many different combinations of two brothers and three brothers, and one is competent and one is not legally competent, etc. But we're just looking at those complex laws to ask the more basic question here: does the instruction of a deaf-mute who is considered not halakhically legally competent to give legal instructions, are we going to allow him to give legal instructions through writing, where he demonstrates that he does understand what's going on, and then we follow the instruction where normally we wouldn't, right? That's the question. So Abaye said, we too learn in the Mishnah, in Yevamos 112b, that nonverbal instructions are not sufficient to initiate a divorce, even for one who was born with the ability to hear and later became a deaf-mute. If a woman became an imbecile, that's different than a deaf-mute, but legally has a similar ramification. An imbecile is someone who is not mentally competent. The deaf-mute, we're not sure if he's mentally competent or not. The imbecile, for sure, is not mentally competent. So if a woman became an imbecile after her wedding, the sages instituted that the husband cannot divorce her. She's not capable of understanding that she's now become divorced. He can't get rid of her like that. And remember that men can have multiple wives. So he can still have another wife and, be fruitful and multiply and reproduce with her. But the wife that he married that later became an imbecile, right, just lost mental competence through an accident or a disease or something like that, he can never divorce her. He's going to be obligated to take care of her. So if the husband became a deaf mute or an imbecile, he can never divorce his wife, who is competent, as he does not have the legal competence to give the get, to give her a bill of divorce. So Abaye explains, what is the reason that the Mishnah emphasizes that this man who became a deaf mute can never divorce his legally competent wife? Isn't this teaching that even though he can communicate through writing, nonetheless he is unable to divorce her? And Rav Papa said, if not for the fact that Rabbi Yochanan teaches us that there is a dispute between Rabban Shimon ben Gamliel and his colleagues, then I would say that Rabban Shimon ben Gamliel comes only to explain the reason of the first Tana, not to disagree with him. If that were so, all agree that one who was born with the ability to hear and subsequently became a deaf mute can issue written instructions to write and give the get to his wife, as opposed to one who was always a deaf mute. Now, he couldn't have even gotten married except by rabbinic decree rather than by Torah law. But then at that point, if he was always a deaf mute, how is he able to write a get? So you might say, well, the only reason he was able to get married is because he could indicate that that's what he wanted to do. And in the same way that he gave that indication, he's now able to indicate that he wants a divorce. But both the marriage and the divorce of one who was a deaf mute all his life would be by rabbinic decree, if it's allowed at all. So we haven't really established, can this person who became a deaf mute give a get to his wife, or he's giving the instruction to write and deliver the get. He's giving that instruction in writing because he can't speak. And according to this explanation, what is the meaning of the word never? It is not referring to issuing written instructions. It means that even though I see he is sharp, he is mentally competent by means of examining his gestures, these indications are not sufficient to warrant the giving of a get. Despite this, if he were to issue written instructions to divorce his wife, yes, they would follow his instructions. Alternatively, the Mishnah emphasized that the only situation where the husband can never divorce his wife is where her husband became a deaf mute or an imbecile, but not if the husband remained healthy and the wife became a deaf mute or imbecile, in accordance with the opinion of Rabbi Yitzchak. As Rabbi Yitzchak said, by Torah law, a woman who is an imbecile may be divorced even though she is unable to give her consent, just as it is permitted to divorce a halakhically competent woman against her will. And what is the reason that the rabbis say she may not be divorced? So that she will not be treated as ownerless property. If she has no husband to protect her and she is unable to protect herself, she may be treated as ownerless property by anyone who wishes to engage in sexual intercourse with her. By contrast, if the husband is a deaf mute or an imbecile, then he cannot divorce her by Torah law. And this is why the Mishnah stresses only that the husband may never divorce his wife in the case where he becomes halakhically incompetent, but not when it is the wife who becomes a deaf mute or an imbecile, in order to demonstrate the difference between the two cases in terms of Torah law. And that concludes our discussion of Mishnah number 1. Needless to say, this is a very complicated, nuanced body of law, obviously when it comes to divorce in special circumstances where the health of one of the spouses has changed, etc., you don't just look it up in the Talmud and then decide what you're going to do. You consult with your local Orthodox rabbi, who is also considered a posek, a paskening rabbi, right? An expert in these matters. We don't just make guesses based on our study. These are very important matters, and you would have to consult with a very competent legal authority before you could do anything. So anyway, that was the discussion of Mishnah number 1. Now, Mishnah number 2 here in chapter 7. If people said to the husband, shall we write a get for your wife? Right? So he didn't say, write a get for my wife. They asked him, they initiated, shall we write a get for your wife? And he said to them, write, meaning write the document. And so those people then, they said, shall we write a get for your wife? And he said, write it. So then they went to a scribe and they told the scribe, write the get. And the scribe wrote it. And then they instructed the witnesses to sign it, and they signed it. So even if they wrote it and signed it and gave it to the husband and then he gave it to his wife, that get is void. It is void unless the husband himself says to the scribe, write the document. And the husband himself says to the witnesses, sign the document. Right? In terms of this kind of, that we will listen to the husband when he has given a very terse instruction, write a get from my wife. Right? We already discussed that. First of all, write a get might only mean write it, not give it to her. The only time he says write a get from my wife and then we write it for him and then give it to the wife and she's divorced is when he's on his way to be executed or he's lying on his deathbed. Otherwise, if a husband just says write a get, all it means, all he's authorized is to write this thing, not to actually give it to the wife. And it's when it's given to her in front of witnesses that the couple becomes divorced. Now, this Mishnah is going a little further in terms of being stringent and limiting the power of the agent to create a divorce for this husband. If the agent said to the husband, shall we write a get? And the husband said, write it. Okay, well, they might write it, but that's all they're able to do, and they're not going to be able to do anything with it. To actually create a divorce, the husband himself has to instruct a scribe, write the get. Right? And then he says to witnesses, sign the get. And then either he gives it to his wife or he specifically himself instructs an agent of delivery, deliver this get to my wife. Right? But if any of these elements are lacking, we're not going to create a divorce out of it. So now the Gemara on Mishnah number 2. The Gemara infers from the Mishnah, the reason that the get is void is because the husband told the people only to write it. But he did not say, give the get to my wife. But if he said to them, give a get to my wife, and they told the scribe to write the document and the witnesses to sign it, those people give the get to his wife and it is valid. Now, in accordance with whose opinion is this statement? It is in accordance with the opinion of Rabbi Meir, who says verbal directives can be delegated to an agent. Everyone agrees that an agent can be appointed to perform an action on behalf of another. But Rabbi Meir holds that an agent can be appointed to give instructions to others on behalf of another, right? I can tell my agent, instruct those people, to walk up the hill and fetch a pail of water. But what only Rabbi Meir holds, that I can instruct my agent to go instruct those people to perform an action, right? Rabbi Meir says you can instruct an agent to give instructions. Normally, I can only, tell people to, right? Say, let's just read that again. Everyone agrees that an agent can be appointed to perform an action, right? I can fetch the pail of water myself, or I can tell people, go fetch that pail of water for me. So I'm making them my agent to go fetch the pail of water. But only Rabbi Meir would agree that I can tell my agent to instruct others to become my agent to fetch a pail of water. Right? Normally, the sages would say you cannot have your agent give instructions to other people. Now, the Gemara comments say the latter clause of the Mishnah that the bill of divorce is void unless the husband himself says to the scribe, write the get, and he himself says to the witnesses, sign the get. So in the latter clause of the Mishnah, we arrive at the opinion of Rabbi Yosef, who said verbal directives cannot be delegated to an agent. So the Gemara asks, is that to say that the first clause of the Mishnah is in accordance with Rabbi Meir and the latter clause of the Mishnah is in accordance with Rabbi Yosef? And the Gemara answers, yes, the first clause is in accordance with Rabbi Meir and the second clause is in accordance with Rabbi Yosef. Although unusual, it is possible for a single Mishnah to represent two conflicting opinions. Now, Abaye said, actually, the Mishnah in its entirety is in accordance with the opinion of Rabbi Meir. And with what are we dealing here? With a situation whereby the husband did not say, give the get to my wife, but rather he only said, write the get. And in that case, he must instruct the scribe and the witnesses directly. If he issued instructions to give the get, it would also have been effective. And the Gemara asks, if so, the Mishnah should have said, the get is void unless the husband says, give it to my wife. So rather, with what are we dealing here? With a situation whereby the husband did not say his instructions to 3 people who constitute a court with the authority to appoint others to write a bill of divorce. A court can give instructions on behalf of someone, but a mere agent cannot. Rather, the husband instructed 2 people, and 2 people do not constitute a court. And therefore, they do not have the authority to appoint others to write the get, even if the husband told them to give the get to his wife. Witnesses may only write and give the document themselves. And the Gemara challenges, if so, the Mishnah should have said, unless he says his instructions to 3 people. So rather, the Mishnah in its entirety must be in accordance with the opinion of Rabbi Yosef. And with what are we dealing here? With a situation whereby the husband did not explicitly say to his agents, say my instructions to the scribe to write the document. And the Gemara challenges, if so, the expression until he says to the scribe, this is imprecise. Rather, the Mishnah should have said until the husband instructs the agents to tell the scribe. And does Rabbi Yosef concede in the case of one who says, tell another person to write it? But didn't we learn in a Mishna on page 87b of this tractate, if a bill of divorce has the writing of a scribe, and the scribe identifies his handwriting, and one witness verifies his signature, it is valid, as if 2 witnesses had testified to ratify their signatures. And Rabbi Yirmiyah said, we learn in the Mishnah that this is the law with regard to the scribe's signature, and not with regard to the scribe's writing. And Rav Chisda said, whose opinion is expressed in the Mishnah? It is the opinion of Rabbi Yosef, who says verbal directives cannot be delegated to an agent, and there is no concern that the scribe signed the document without the husband instructing him to do so. We're now on page 72a. I'm almost done. If you've got questions or comments, please get them in. And if it enters your mind to say that Rabbi Yosef concedes in the case of one who says, tell another person to write it, a pitfall would result from it, as sometimes it happens that one said to 2 people, tell a scribe and he will write the document and tell so-and-so and so-and-so that they should sign it. And due to the shame of the scribe who asks, don't you consider me a sufficiently upright person to sign the document as a witness, as well as writing it up as a scribe? And the agents are concerned to avoid that disgrace, and they will have one of those witnesses and the scribe sign together with him. And the husband did not give this instruction. Rather, he said, tell the scribe to write and those 2 witnesses to sign. And then they changed the instruction, and they said, well, let the scribe be one of the witnesses who signs. So now they didn't follow the husband's instruction. So if they then take this get and give it to the wife, is it a valid divorce or not? This bill of divorce is not valid because it was signed contrary to the husband's instructions, and the agents will mistakenly think it is valid, and that is the pitfall we seek to avoid. But the reason that this is not a concern must be because Rabbi Yosef holds that even if the husband says to the agents, tell the scribe to write, the bill of divorce is not valid. Rather, it is clear that the first clause of the Mishnah is in accordance with the opinion of Rabbi Meir, and the latter clause is in accordance with the opinion of Rabbi Yosef, which once again sounds unusual. Is this really what's going on? We'll find out tomorrow when we continue with page 72 at our regular Monday time of 6 p.m. Pacific. All right, let's see if we got some questions or comments. Load Google Doc. Just one question from Sharon. What becomes of the estate of carrying on the name of the deaf-mute brother? Are his of no significance in the eyes of the Jewish practice at that time? I guess you're saying if the deaf-mute brother, right, who married his wife by rabbinic decree, right, that was a marriage by rabbinic decree, not by Torah law, and then he dies childless. Does the wife now fall to the halakhically competent brother for yibum? And it seemed like they were saying no, because a marriage by rabbinic decree doesn't trigger the yibum exception. Remember, the yibum law is an exception to the general law that a woman may not marry her husband's brother. It's only if he's childless, right? If a man has children and then he dies, leaving a brother, the wife will never be permitted to marry that brother, even though her first husband is dead, because a woman is not permitted by Torah law to marry a man and his brother, even if the first man dies. The yibum situation is an exception to raise up the estate of the one who died childless. So Sharon is asking, is it that the law doesn't care about the deaf-mute man's name and is, raising his estate by creating an heir for him? And I'm not sure that it would say that the law doesn't care about him, but rather that in that situation, we don't move forward with the exception to the more general principle that it's considered a prohibited union for a woman to marry the brother of a man that she was already married to. That's what I've got for us today, and with God's help, we'll be together again tomorrow at